Oh, and so here again, you've been the local constitutional kook out here in California. And an important subject matter for today, and bear in mind with administrative states, this applies across the board to all of them. The subject matter today, though, is homeowners association. I mean, but these people are so unbelievable. But the good news is we've got them dead bang. Because number one, you have a right, unlimited power to contract. That's the Constitution of the United States mandating in Article 1, Section 10. And the Supreme Court has ruled in at least a case called Hale v. Hinkle 201 U.S. 43, unlimited power to contract, presumption of competence. Exactly the opposite of what goes on today, courtesy of the non-existent 14th War Amendment. Upcoming videos on that subject. But that said, I really can't tell you what to do. And if they have an LLC, and almost all of them do, limited liability corporation, they're not registered lawfully anywhere, even if it's quote unquote in your state. Because the problem is there are no states. We can prove it, and you'll learn from that. Send me an email, uwinningsport@gmail.com, and we'll get into all of these issues. So we have that one. And we have the fact that registered at all, they're in a territorial secretary of state. You are domiciled in a state judicial district. They can't make effective service process on you. And there's that pesky U.S. Supreme Court again saying it, not me. You'll learn all about that. Send me an email, uwinningsport@gmail.com. And they've absolutely got nothing. And they exercise powers, by the way, if they're created by the de facto national socialist government, and that's what it is, people, like it or not. They only have such powers as that government might have. But as you're going to learn, that government, with regard to us, has zero powers. All they have, if that, is pursuant to artificial corporate entities that are what I call their birthright citizenship. The Section 1 of what we can prove is the non-existent 14th War Amendment. That's it. Well, it doesn't matter how much good they think they're doing or this, that, and the other. And they can come along and tell you, what color your, windows should be and a lot of other crap like this. And none of it makes any sense. You do basically what you want to do. And that's the way it should be. It's your house, you bought it. And there's another big problem that comes up, by the way, the ever-present money issue. Because when you bought your house, quote unquote, or making payments on it, you're doing so with undefined dollars, otherwise known as Federal Reserve notes. Give me a fucking break here. And it doesn't matter, by the way, because the big deal is that on the other side of the coin, especially in Washington, D.C., and any government agency worthy of the name today, they think all you have is an equitable interest in your property, because with these notes, you discharge the obligation, but the debt's still due. You don't have any property rights that an HOA could possibly violate now, do you? Well, not in a federal insular territorial possession, you don't. In a sovereign independent state admitted into this union, and there were 32 of those up until 1859, that's a whole different subject. And I think generally in territories which are in states of pupillage at an earlier time preparing to become states, that's also true. And these are the kind of arguments that we need to make. I'll show you how to do it. But it's just so much good news, I don't even know where to start here. But the big deal is you get these arguments in there in front of a purportedly neutral judicial magistrate. The other side isn't even going to oppose it. And if they do the right thing and dismiss the HOA, that's even better. Because that's where our power comes in, people. We have it and they don't. We get one case decided like this in my hometown of Washington, D.C. with the 9-0 parts. But the AK, the U.S. Supreme Court, that voids every HOA registration from Portland, Maine to Portland, Oregon. It puts them out of business, exactly where they should be. That's leverage. And we have a Supreme Court today in its fourth term of an all-out assault on the administrative state that governs, the homeowners associations for right or wrong or good or bad. But we're not subject to any of that BS. We have rights secured by the Constitution, as you'll learn, Article 1, Section 9 and 10, as the case may be, to judicial process from day one. That's in effect the judicial court, which you never see, especially with HOAs, and the right to trial by jury according to the course of the common law. Now, they want to make changes and do it that way, and if they had standing in the judicial court, by the way, and none of them does. And that makes every law on the books null and void, nunc pro tunc ab initio from day one as a bill of attainder. And we have the U.S. Supreme Court saying it too, and the justices today damn well know it. It's all good news for us. We certainly want to get them to move faster than they have been. I get that part. I understand it very well. And the justices know I understand it very well. In fact, I've had some really good things happen in my Iowa case. That's another video coming up here. I'll let you know what's going on there. It looks like I've actually gotten through the report not only once, but twice in that case. And if that's true, that's leverage up the wazoo for all of you out there with these HOAs. If I can take down the quote-unquote state of Iowa, that's their boss, their sovereign. What are we going to do to them? And that's exactly what we want to do. Get them out of there, put them out of existence. So it's just all good news here. And I'll have more to say in the next set of videos coming up. This is Monday, I think. I'm not too good on days of the week here, but I'm great on the Constitution, laws, and history of the United States. And these are the kind of issues, that you want to learn and put into your case, and you set an unopposed record against these bastards. They're never going to answer any of them. Hasn't happened in the entire time I've been doing my work. And what that does is convicts them of treason to the Constitution, because Article 3 not only mandates that the judicial power of the United States shall be vested, the Supreme Court has ruled in Cohen's v. Virginia effectively the same thing. You're going to learn more about that case. That's one of those old vintage cases. They don't use that anymore. The hell they don't. They've cited it recently in the last 4 or 5 terms, and more than once, too. When you realize in there, what does it say this is a dead bang quote here, that the Constitution gave to each person having a claim on a state a right to present his case to the court of the nation, no matter how small the claim or how little the interested community in its outcome. The framers of our Constitution thought it important in the interest of justice to create a tribunal as superior to influence as possible in which that claim might be decided. And that's one of the reasons that I'm so excited at my age, and I should know after 42 years doing this, and I'll be 76 later this year, I should know better. But I see it coming, and the justices see it coming, and we're going to get them to move. You'll learn some of the ways we're going to do that by getting my modestly priced constitutional defense document packets. Send me an email, youwinnincourt@gmail.com, and we'll get a lot done. And we might end up encouraging the justices, since I know the timing isn't quote-unquote right just at the immediate moment. But what they can do is take our case, your case, and put them on the docket for the next term, beginning the first Monday of October, and they stay all proceedings in the lower courts until that happens. That gives them a window to get around the issue that we have, for example, a quote-unquote election coming up this year. You'll learn more about that on other videos too. But they know as well as I do, timing is a bit quote-unquote impractical. And yet when we get there, the courts also said another important case will learn about Ashland v. Tennessee Valley, 297 U.S. 288, page 341. The court will not address an issue of constitutional law in the event of the necessity of deciding it. You don't ask, we won't answer. And they know on that court for at least the last 90 years that none of their attorneys in the Supreme Court bar in their right mind are going to bring any of the unopposed constitutional issues I advocate. What happens, though, and this is true, by the way, with Roe v. Wade and abortion, and ladies out there, Roe v. Wade never existed. The court damn well knows it. You get up there under different provisions of the Constitution, you get a much better result. A video for another day. But that said, they say right in there in Ashland that the court will not address an issue of constitutionality in advance of the necessity of deciding it. You don't ask, we won't answer. And they know damn well their attorneys in the U.S. Supreme Court may not even understand a lot of these, let alone present them, but they have the sworn duty to do. You're going to love this when you get my materials, how we can prove that. And that with the mandatory public education system, and education is in quotation marks, especially with all the woke crap, transgender BS, and LGBTQ crap going on there. The 3 R's are out the back door. There's no learning in there whatsoever that anyone can possibly know what rights they have to present to the U.S. Supreme Court. And we're going to be fixing that too, so it gets more out there, and I hope the justices do that quickly. And we get our education system back. And by the way, it was a bit better when I was in school all those decades ago, but not in this area. I got school right outside of Washington, D.C. If I would have heard anything more about Andrew Johnson and the fact he got impeached, my life would have been different 60 years ago. Better late than never. I'm doing it now, and I'm trying to help you. Now send me an email, youwinnincourt@gmail.com. And this is across the board, not only with these idiots, but other idiots, the Child Procurement Syndicate, for example, the Traffic Court, Tax Court, you name it. These issues apply across the board because you're never in a judicial court at any time, and we have the right to one of those from day one, not to mention common law trial by jury. And as you'll learn, that's true even for inhabitants of territories, for crying out loud. And yet lawful deserved just San State citizens don't have any of these rights today. That's what we're going to fix, and that's what I was put here to do, is to help you fix it. So it's exciting, it really is. So send me an email, youwinnincourt@gmail.com, and we'll take these HOAs on, and the good news is we can put them out of business, and they are subject to the 14th Amendment, unlike Donald Trump, Section 3. No way. What he's doing is trying to put the original intent back in place in our federated Republican form of government of defined and limited powers, while getting rid of today's elective despotism. 3 wolves, 2 sheep, voting on what's for dinner. The sooner we get rid of that, the better. So that said, send me an email, youwinnincourt@gmail.com. Subscribe, like the videos, tell your friends, get the word out. Thank you.